Let us simplify the common law. The law is similar, right, for state and people. There is no privilege. Equality before law, fine. Dicey's concept of rule of law, that is common law. All are equal in the eyes of law. There is a single legal system to deal with justice and other issues. There is hierarchy of court. There is supremacy of judiciary. Now, continental law, which is a feature of, again, France and some other countries, right? This is also called as administrative law system that you study in your administrative law chapter. French droit administrative system. It is also called administrative law system. Yes. The problem here is that here we treat the justice system and the legal system to be governed by a single institution, judiciary. Right? See, no one else can interpret the law. No one else can give the justice but the judiciary. The final interpretation of the law is made by the judiciary. Simple. Others have to conform to this, right? Unified system, integrated system. Okay? Now there are two portions of the legal system. One managed by the judicial system, other managed by the administration. So in France, you have two legal systems, judicial systems operating on two legal principles. One, administrative court system, other, judicial court system. So what does administrative law mean? It is not a common law, it is a dual law system. As it is a dual law system, do you think it is good for people or bad for people? Good for us or bad for us? There are two types of legal systems existing. So when you become bureaucrat, it is good for you. Why? You will get protection under this legal system. You will have privileges under this legal system. Why? Because for administration, the legal system is separate. Administrators are well protected by this administrative law or administrative court system. So they have separate laws, codes, privileges, everything separate. That means when an administrator commits a crime, when an administrator is in conflict with citizen, or citizens have conflict with administration, where will they be tried? They will be tried in this court, not in the normal judicial court. You understand? India aisa to hai nahi. You have any conflict, you go to the court. That is why we created tribunals. So tribunals are a kind of administrative courts, or they are not technically courts, but you can say quasi-judicial bodies. We created it. So somewhere we are trying to copy now, see, administrative law system. That is why we say there is a growth of administrative law system in common law countries. See, that is also a question in UPSC. Why the need for increasing tribunals in common law country? All tribunals are courts, but all courts are not tribunals. Question, why you see?